she recommended to Mr. Floyd to go down to the hospital. That does not mean that her video statements to him are admissible. I think it makes more sense for her to explain why she took the action she did. The subsequent treatment at the hospital, and the defense noted that Mr. Floyd was violent or otherwise, none of that is admissible. So what we have here, what I'm going to allow, is a portion of the videotape of the one officer from the time he approaches the car until Mr. Floyd is out of the car and handcuffed. And
testing for Monday, but just trying to get everything set up right.
There's a shot of the back of his shirt. He's wearing a black shirt. At that point, he's been handcuffed. That's all that.
Yeah, the camera, it's a little messed up right now.
The pills that are in the track of the seat would also, there's a photo.
We're just doing a little testing.
That would be admissible also as part of that.
We're going to let her run for a little bit, see how she runs.
And then the blood pressure and Mr. Floyd's statements regarding that were made for purpose of that medical diagnosis. The whole point here is we have medical evidence on what happens when Mr. Floyd is faced with virtually the same situation. Confrontation by police at gunpoint, followed by a rapid ingestion of some drugs. We don't know exactly how many, but there was an admission that he had done it at the time of the stop. That is medical evidence. So we don't have the benefit of on-the-scene medical vital signs on May 25th. So the May 6th, 2019 case is relevant only to that extent. Mr. Floyd's emotional behavior, calling out for his mother, all that is not admissible because the emotional behavior in his state of mind is not relevant. The May 6, 2019 evidence is only admissible for the limited purpose of showing what Mr. Floyd's, as an example of Mr. Floyd's bodily reaction, his physical symptoms upon being confronted in almost the exact same situation. Now, how does this affect the decision on Dr. Vincent's testimony? Dr. Vincent's report and her testimony would be strictly psychiatric evidence going to the state of mind of George Floyd. As I've said, this is not admissible. It's not by either side. The behavior itself is manifest on the videotape. And I believe the state has one expert who would say, the behavior you see on the videotape is not consistent with a cardiac arrhythmia. Perfectly appropriate opinion based on what they see on the videotape. To go further and say, have a psychiatrist say, this is due to or just consistent with anxiety, hypertension, or not hypertension, anxiety, claustrophobia, panic attack, really is just opining on the state of mind of Mr. Floyd and the mechanism or why he is acting the way he is. If the defense were to attempt to say that he's simply malingering, that would be speculation, and I would not allow that either. Because Dr. Vincent's testimony would go to the state of mind and interpreting the emotional behavior and its cause, that is anxiety, panic attack, claustrophobia, or even PTSD, is not admissible. Having said that, if the state believes that there is something the defense has done to open the door, we can discuss off the record or at least outside the hearing of the jury if the defense has opened the door to Dr. Vincent's testimony. Keep in mind that would be in rebuttal. Keep in mind further that if I allow Dr. Vincent's testimony, then the entirety of the May 6th case would be in because the defense would have a right to confront her opinion by playing the entire videotape of Mr. Floyd's emotional reaction on May 6th. And I think this illustrates both the benefit of motions in limine and the disadvantage of motions in limine. Number one, the benefit is we can try and parse through a lot of these very detailed evidentiary issues before trial so that we are not taking long recesses to discuss and brief while the jury is waiting. And so this is absolutely appropriate that this was dealt with by motion in limine. The disadvantage is we cannot, to every extent, script out this trial. Trials happen in real time, and there is just the true nature of it that things change. So accordingly, let's go with that idea, is that if the state feels that the door has been open, we'll have a conference about that and I'll decide. But keeping in mind that if it is open, it's probably open to all the evidence regarding Mr. Floyd's emotional behavior and its evaluation. So that is the court's ruling. We're going to try and get as much of this down into a written memorandum. Over the weekend, Mr. Schaefer and I will be putting in some time to firm this up. But that is the limits that the court will allow. I think this is consistent with the Ness case, which said that it can only be for a limited purpose. And the amount of evidence regarding that limited purpose has limits as well to try and keep out as much evidence as possible. Now, as to the motions for continuance and for change of venue, the purpose of a change of venue is to ensure that the defendant has a fair trial by an impartial jury. The same is true as the basis for the defense's latest motion to continue, with the hope that as time passes, people forget some of the pretrial publicity. Unfortunately, I think the pretrial publicity in this case will continue no matter how long we continue it. Perhaps some of it may, with time, be forgotten by people. And as far as change of venue, I do not think that that would give the defendant any kind of a fair trial beyond what we are doing here today. I don't think there's any place in the state of Minnesota that has not been subjected to extreme amounts of publicity on this case. Change of venue is an option in the rule when there is extensive pretrial publicity that is prejudicial, and there was prejudicial pretrial publicity, including the latest actions by the city of Minneapolis in settling the case. I'm not questioning whether they could or should settle the case at this time, but the bottom line is when it's reported by the press, it can affect the jury.
Yes, sir.
Prejudice or taint our jury pool. I'll be very honest, when that was first brought up by the defense, I thought they were overstating it. I thought this really won't have an effect. People know it's a different case, different situation. I was a little shocked when we called back all the 9 jurors who had been seated, and 2 said it did move them off of being fair and impartial. We had all accepted them as fair and impartial jurors. 2 of them basically said that they could not be fair and impartial any longer. I was surprised that it had such an effect. That's probably a judicial bias. As a judge, I'm used to, okay, that's not relevant, so I'm just going to put it aside. So it is easy for me as a judge to disregard the fact that the city settled, knowing that it's totally different factors. But I have to remember that that's not the point of view that jurors are coming from. And so 2 said that they could no longer be fair and impartial. They were stricken. That left us 7. It is important to note that the other 7 did not feel that it was going to change their ability to be fair and impartial. Ultimately, on a motion to continue to ameliorate prejudicial pretrial publicity and continuance or change of venue for those purposes is to find a fair and impartial jury. We have had 8 full days of voir dire from March 9th through March 18th, and now we're going to continue hopefully to select 2 more jurors. We had an initial jury pool of 326 from the random draw on February 1st based on all the summons jurors who returned questionnaires. We have gone through 95 panel members as of March 18th. 57 have actually been questioned. 22 were excused for cause on the parties' joint motion based on the review of the questionnaires. 16 were excused from the panel by the jury office between February 1st and March 18th after having completed questionnaires due to postponements, ineligibility criteria, for example, no longer resident of Hennepin County, non-citizen, over the age of 70, health-related, etc., but prior to questioning. Of those 57 panel members whom we have actually questioned during the 8 days of voir dire, we have selected 12. Defense has exercised 12 peremptories. The state has exercised 6. And the court excused 27 for cause after individual questioning. I think it's worthy to note that I did give both sides extra peremptories. And people may wonder, how does that help? If I'm not going to change venue and I'm not going to continue the trial. There are jurors who are very clearly incapable of being fair and impartial. Some will come right out and admit it. Those are the easy ones. The court can excuse those when they say, for whatever reason, I cannot be fair and impartial. The next set are those who the court makes a finding that based on the totality of the circumstances cannot be fair and impartial. As I've said a few times during voir dire, just saying the magic words, they can be fair and impartial, does not end the court's inquiry. The court has to consider the totality of circumstances and decide if it has been established that they cannot be fair and impartial. There's a third class of jurors who don't say enough to establish a challenge for cause. Yet there are concerns that they still might harbor certain biases, and maybe it's rarely that they are lying to the court or to the parties. It's usually that they just have not done sufficient introspection, to be honest, and see how their biases affect them. It is for that reason that a peremptory challenge can be made if the parties believe that a person cannot be fair and impartial, that they would be biased against their client, be it the state of Minnesota or the defendant. That's the purpose of peremptory challenges. More were given after the settlement announcement because that would add an added layer of potential prejudicial pretrial publicity. And so to get at that third group, which might have grown in size because of their exposure to the settlement, that's the purpose of giving both sides additional peremptory challenges, to focus on that third group, which although they heard about the settlement, said they could be fair and impartial, but we all, or some, the striking party, had concerns that they could in fact be fair and impartial. And that's an appropriate exercise of peremptory challenges. Obviously, challenges based on race or gender, and that being the reason for the strike, are improper, and we've dealt with those on the various challenges that have been brought. With that, we'll continue with jury selection. We will continue with jury selection in this case and in this county. Accordingly, we'll take a break till 9 o'clock when our first juror is here. So we'll stand in recess until that time. Thank you. Accordingly, we'll take a break till 9 o'clock when our first juror is here. So we'll stand in recess until that time.
All right, I'm gonna call this test done. Want to see how everything looks. I think it looks good. I'll rewatch it a few times, make sure something's not off, but all right.